you said your name, the name of the party that you represent. But what I tell attorneys
All rise. The honorable justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before are admonished to draw nigh and give their attention to.
Please be seated. Good morning. Welcome those in the courtroom as well as those that are watching our live stream. Now ask Mr. Doug Shima, the clerk of Kansas Appellate Court, to please call the 9 a.m.
Your Honor, may I please? First case on the 9 a.m. docket for Tuesday, October 29, 2024. Appeal number 126844. State of Kansas versus Robert Smith, Sedgwick County, Breesville.
May it please the court, Lindsay Carnegie from the Kansas. Half of my client. I'm ready for argument.
Please the court, Assistant District Attorney Matt Maloney, state, present and ready for argument.
Second case is appeal number 123710 in the matter of the parentage of E.A., Shawnee County, briefs both sides.
May it please the court, Attorney Joseph Booth appears on behalf of DA, the appellant in both cases, and I want to reserve 5 minutes for.
5 minutes is.
May it please the court, Rebecca Phelps Davis for DP and SP appellees in these matters. Ready to present our case.
Your Honor, that concludes the 9 a.m. docket.
Thank you. I will now call 12684 State of Kansas. As counsel come forward and get settled and take your time doing so, just make a couple of introductory remarks for those who may not be familiar with the processes of the court. The court has received the record from the court below on the cases that we'll hear. We have had the opportunity to read the briefs, the written arguments, as well as do our own internal work and research. We've reviewed the record or portions of it, at least in each of the cases. Those portions of the record are relevant to the questions that are. That means that we've made notes to help ourselves remember all of the volume of materials that we've read. Some of us have those on computers, some of us have those on paper. And you will see us consulting those. We do have hear the arguments of the counsel. We do that not because we're distracted, but because we are checking ourselves, we are looking for information, and we are using that process to help us understand the arguments of the counsel. And with that, Carnegie, if you'd like to come forward. You may proceed.
Chief Justice, and may it please the court, Lindsay Carnegie from the Kansas Attorney's Office. Your Honor, with the court's permission, I'd like to request
3 minutes is granted.
Thank you. We're before this case on a direct appeal felony murder conviction. There are 6 issues briefed in this case. There's a common thread that ties these issues together. And that common thread, the state was desperate. The first trial resulted in a trial with a jury hanging all counts against my client. And during the second trial, the state was ready to do whatever it took to get a conviction against my client, even at the expense of his constitutional right. Trial is fair trial. I'm hoping to address constitutional speedy trial, that's issue 1, and also, if there's time, issue 2, the prosecutorial error. So focusing on the constitutional right to a speedy trial, my client Robert experienced textbook prejudice in this case. And that's because before the retrial, one of the state's key witnesses, Stephen King, died. And there are serious issues. The briefs and the records show that the defense counsel believed that Stephen King committed these murders and not my client, Robert Smith. So it was imperative for the jury to see live testimony from Stephen. The jury needed to be able to accurately assess this witness's credibility.
Let me ask you a question. So, our test, the first thing we talk about is presumptive prejudice. And then the fourth element is actual prejudice. So where do you stand on presumptive prejudice? Give me your take on that.
Your Honor, can I clarify? Are you asking about kind of the threshold factor and the length of the?
Yes.
Yes. So this court has not exactly addressed the issue yet of the length of delay between trial and a trial. In the briefs, we cited Nebraska v. Short, and this court has cited Short in the past. And in Short, they were dealing with an 8-month delay between trial and the retrial. And they said that's not presumptively prejudicial. But here in Robert's case, it was almost 3 times that.
And was that during COVID?
Your Honor, the time between first trial, the time of arrest in the first trial, there was some COVID delays, but between the retrial, this trial and the retrial, it wasn't impacted by COVID. There were really for the length of the time.
Well, when the parties originally set the trial date, almost immediately after the trial, it was set for about 6 months later, 3, I believe.
That's correct, Your Honor.
And that was in consideration of everyone's calendars, including the right?
That's correct, Your Honor.
And you agree that at the point of mistrial, the speedy trial concerns start over.
Correct, Your Honor. The speedy trial concerns would start over.
I want to push back a little bit, ask you about Stephen King. It's not very often that there are mistrials and retrials, 2 separate trials. But isn't it just as possible that Stephen King's testimony, the retrial, would have actually been more favorable to him, favorable to the state, in that he may have corrected some of the problems that existed in the first trial?
Your Honor, with respect, I'm not willing to concede that it would be more favorable to.
I'm just asking if it's possible.
Yes, Your Honor, it is possible, but to push back a little bit, the jury needs to accurately weigh credibility and they need to see testimony. And that's the same reason that we as appellate lawyers and appellate courts do not reweigh witness testimony at cold trials. So I see the point that perhaps it could be favorable to my client, but I'm not willing to concede that point, particularly for this witness, when defense's theory was that Mr. King was responsible.
Well, what would happen if Mr. King passed before trial, but after preliminary hearing, you have preliminary hearing transcript? What would happen in that case? I guess I don't see the prejudice springing from Mr. King's death, because unfortunately, that does happen. Witnesses are unavailable, or they pass, or for health reasons can't testify. Why is that so crucial here, in light of other circumstances that can occur?
Right, Your Honor. To address your first concern about whether a preliminary hearing transcript would be, different rather than a trial transcript. And I guess that kind of just depends on the nature of the preliminary hearing, whether the defense had the same theory at the preliminary hearing as they wanted to advance at trial. So to answer that question, I'm sorry, could you repeat?
Well, basically, Mr. King was unavailable. I mean, that's what happened. He passed for lots of reasons. Witnesses are unavailable, and other types of forms of testimony are used at trial, as long as confrontation rights are preserved. And that's what happened here. What's the difference? I guess I'm not seeing why his death is. You started your presentation. That was the critical part of your claim here.
Your Honor, again, I'm sorry to repeat myself, but it just goes back to the defense's theory, and this is such a key witness.
Right.
The defense believed that Mr. King was responsible for this murder, and the defense would have rather live testimony to accurately.
And I understand. Okay, thank you.
As I recall, at least theory was that Mr. King and Mr. Smith had at least some physical resemblance, enough to have perhaps meant that the of Smith was in question. What was done at the trial to give the jury some idea?
Well, Your Honor, during the retrial, Mr. King's picture was displayed on the overhead while the trial transcript was being read. And I can't recall whether defense was actually able to make much of an argument about the resemblance. Briefed in the third issue, defense counsel is precluded from making many arguments that Stephen King committed this murder.
Did you make a proffer as to what evidence you would have presented if allowed to try and implicate Stephen King, which you were precluded from doing?
Yes, Your Honor. I believe there was a sufficient proffer in this case. Prior to the first trial, there was a motion made from the state asking and coming in. So this was litigated below, and defense counsel did make a proffer. The standard is that it doesn't have to be a perfect proffer. It doesn't have to be a question and answer. But defense counsel did make a sufficient enough proffer that the district court was able to accurately rule on this, and that this was a close. As far as the substance of that proffer, have a moment. So the proffer was that Stephen did resemble the identification given by the eyewitnesses in this case, that Stephen previously possessed a handgun matching the caliber. Stephen's familiarity with the victim in this case.
I'm sorry, I didn't hear that.
Oh, I'm sorry. Stephen's familiarity with the victim in this case. The fact that Stephen's prior residence was also the victim lived. And that Stephen disclosed information related to this murder shortly after it was committed, and that he had a lot of key information about this murder. Defense counsel's theory was that he was a perpetrator. Your Honor, if I could, I'd like to move prosecutor's errors issues. There were 3 different prosecutor's errors, and I'd like to focus on the first that was briefed. That was the error in the state's arguments that kind of improperly suggested to the jury that the victim's son, Clifford, could have identified my client, Robert, as a shooter if he had been asked that question. And there's a lot of background to this question. I'm going to skip ahead. I know the court has read these briefs, but I guess, and I'm trying to be as polite as possible and not inflammatory, but it felt like pure censorship. The state presented this argument that, and this evidence hadn't come out at trial, that if only Clifford had been asked this question, that he would have identified Robert as a shooter. And they left out all of the exculpatory information about how Clifford couldn't identify my client as a shooter the day after the shooting. So that's very prejudicial in this case.
But in the defendant's opening statements, the counsel for the defendant went pretty extensively into what they expected Clifford was going to say, right?
Yes, Your Honor.
And in fact, during the testimony, Clifford didn't say those things, did he?
That's correct, Your Honor. I'd like to make a couple qualifications on that if I could. Based on the retrial or based on the first trial and a lot of the pretrial litigation, it was reasonable for the defense to expect there to be this eyewitness testimony. It followed, a reasonable belief from what happened in the first trial. And even so, to put it colloquially, two wrongs don't make a right in Kansas, even if defense counsel says something improper, which I'm not conceding that they did, but even if they did say something improper, the prosecution can't rebut that even in the heat of battle with.
Well, but wasn't it a strategic decision for the defendant to try to deflate the balloon of what the prosecution's case was going to be by giving the jury its version of how Clifford's testimony should be viewed? And that was a risk the defense took, that Clifford would actually say those things, wasn't it? I mean, wasn't it fair for the prosecution to respond to that?
No, Your Honor, I don't believe that it was fair because the evidence didn't ultimately show that. And the state was asking the jury to make an improper inference. The evidence didn't show that. And Your Honor, I see that I'm out of time. I would.
I see no questions. Thank you. Mr. Maloney?
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I will also focus on issues 1 and 2, unless this court has questions about the remaining issues. Beginning with issue 1 and counsel's assertion that the state was essentially desperate at the retrial to convict the defendant at all costs. Our position is that the record simply does not show any indication that that was in fact the situation. The retrial was ordered after there was a mistrial. The court, as Your Honors pointed out, the court went about setting the matter as quickly as possible while also taking into account the attorney's schedules. I think the only thing that the defendant can point to indicate that the state was desperate would, I guess, be the fact that, unlike at the first trial, the state decided to pursue DNA testing at the retrial. But I would note that, first of all, that's a decision that the state is entitled to make. As I argued in the brief, retrials are never going to be carbon copies of the first trial. There's always going to be some differences between the first trial and the second trial. Presumably, both parties, both litigants will take some lessons away from the first trial. Otherwise, we would just have a transcript read to the jury at the retrial of the exact testimony that was presented. So it's not at all uncommon for both parties to make different strategic decisions about how they're going to try the case. And there's certainly never even been an assertion by the defense that the decision not to seek DNA testing at the first trial was somehow done with an eye on the second trial and creating a speedy trial issue.
How did the that DNA testing affect the complexity analysis of this case? Because just considering, I'm trying to ask a question about presumptive prejudice and, 21-month delay, typically I don't know that there's a lot of case law that doesn't find it in that context, but we don't just look to the amount of delay, we look to the circumstances and complexity. And I'm curious, the state's perspective, how that sort of new DNA testing impacts that complexity.
Yeah, and this issue is always somewhat tricky for me to conceptualize because I realize that in a lot of the cases, it just strictly looks at the time frame and that the reason for the delay is a separate factor. But I do feel like there have been cases in which this court has taken into account that if the delay is not due to any fault of the state, that you shouldn't just automatically consider the entire amount of time.
But I think you're getting into the merits of that, which goes to factor 2, 3.
Right.
Factor 1 is the presumptive prejudice. Really, the only thing I think we can consider is, as Justice Wall said, the complexity of the case. As, you know, was it a simple drug deal where everybody knew what was happening? Is this, you know, on the other end of the spectrum, a conspiracy case involving lots and lots of people? So I'm interested to know, just based on complexity, what's your best argument that a 21-month delay was not presumptively prejudicial?
Sure. I think clearly this is a felony murder case, which right there, the severity and the of the crime itself and the stakes of the case would certainly argue that this is a complex case. This is not something where you could or should expect that it's a case that could just be tried very quickly. DNA testing is obviously something that is well within the bounds of the state to seek in a case like this. And DNA testing does take a little bit of time. And then, and I know this is somewhat veering into the second factor, the reason, but we see that the actual testing that was performed by the state only took a few months. So everything from that point forward was due to challenges that the defense had in trying to find their own expert to either independently test or evaluate the results of the state's testing. So I think when you lump all of those things together, I think that this is a case where there is a serious question about whether 21 months gets the defendant to the point where we need to go beyond the first step and analyze the remaining factors. Clearly in the brief, as always, I did address factors, and I'm more than happy to discuss those, because I think it really does show in this case that even if the defendant meets that threshold to get to the last three factors, he certainly does not prevail on the merits of the claim.
How does the fact that this is a retrial impact all of this? In terms of, the defendant argues we shouldn't even talk about the DNA complexity because the state had the opportunity to have done that before the first trial, and so and under these circumstances, do we in some way accumulate the two time periods when we look at the time, or diminish the complexity factor because it had already been tried, and presumably all that complexity could have been worked out before the first trial?
Thank you. I appreciate the question, and my response is that no, we do not. And I think the case line counsel's correct. There doesn't appear to be a specific Kansas case on point with respect to constitutional speedy trial. But I think both parties agreed in the briefing from citing the foreign jurisdictions that when there is this situation, when there's a mistrial and a retrial, that you simply consider the time from the mistrial, from when the mistrial was declared. And as a result of that, we can't look back and say, well, the state could have chosen a different route the first time. And if they had done that, then the resulting time between the trials might not have been as long because the DNA testing could have already done. I think if you do that, then you're ignoring the case law that says that you're just looking at the time between the two trials. And again, I think I realize it's not a constitutional issue, but it was a statutory speedy trial case in, I don't know how to pronounce, whether it's Blaurock that I cited in the brief, Court of Appeals case, where it was a similar situation where there was a mistrial declared, and then this issue arose, and essentially what the Court of Appeals recognized there is that parties are allowed to make strategic adjustments between trials. And you can't second guess and say, well, the state could have done something differently the first time, and that might have lessened the delay between the two trials. They essentially said that the state had reason to believe that the strength of its other evidence at the first trial was such that it wasn't necessary for them to pursue that route, but that the decision to do so at the second trial was reasonable and something that they were entitled to do based on the way that the first trial had proceeded. And I think that that's essentially what happened in this case. And it's always easy to go back and second guess and say that such and such should have been done. But that's always with the benefit of hindsight.
It's not, I don't think it's necessarily second guessing. I think what Chief Justice maybe was getting at is, once you've done it once, yeah, maybe you're going to make some adjustments, but doesn't that suggest that it's the complication of it when we're considering presumptive prejudice is diminished to some extent?
I understand the point, but I do think, though, that if you take that into account, then you're essentially making the rule that you're only supposed to look at the time from mistrial to retrial. You're creating an exception there that swallows the rule, because you're backdooring that factor and that analysis into this factor. And our position is that you simply can't do that. And you should not consider the fact that, yes, theoretically, this could have been done before the first trial. So I think that you should analyze it essentially as if this was the first trial, and you're looking at it with a fresh set of eyes, and you're not taking into consideration whether something could have already been accomplished, and therefore it would not have been as long of a delay the second time around. But I think that looking at the reason for the delay, again, it only took a relatively short period, a few months. I have in the brief, and obviously the record speaks for itself, the exact time frame. But of these 21 months, the vast majority of that was time that the defense struggled to find their own expert. The state's testing was conducted and finalized relatively quickly. And then after that time, it was the defense that had a very difficult time finding an expert and getting the expert to do the analysis. And I'm not suggesting at all that the defense was not entitled to do that. Clearly they were. It's an important case, and they have every right to pursue an expert on their defendant's behalf. But that should not be counted against the state when the state's testing had already been conducted, and the state would have been prepared sooner. But the defense was trying to have their own expert found, and it was difficult to do that. So looking at that as a factor for the reason to delay. And then I'd also note that the defendant did file multiple motions during this period where he was seeking to have his attorney removed from the case and new counsel appointed. And while those were denied, and that obviously didn't result in any actual delay, the very fact that he was repeatedly seeking to have new counsel appointed, that necessarily would have resulted in a substantial delay to the case if any of those motions had been granted. And so I think that would strongly indicate that the defendant was not in a huge rush to get this case to trial. And so whether that's looked at as part of the reason for the delay, or more accurately, maybe the assertion of the right, that while he was complaining about speedy trial, he was also himself affirmatively agreeing to continuances for his own DNA expert. He was trying to get new counsel appointed. And it's also noteworthy that in the speedy trial motion that defense counsel filed, DNA was mentioned very briefly in passing. It simply was not a focus of the argument that the defense was making below. I think a fair reading of the record, in my recollection, is that defense counsel understood that, look, DNA is it's something that needs to be considered here. We need time to get the experts to analyze it, or perhaps even do testing. So the defense attorney was not even really complaining about the amount of delay resulting from the DNA. And then turning to prejudice, and counsel has focused largely on the absence of Mr. King. And I point out, and I think some of the questions from your honors alluded to this fact, I would argue that King's absence, to the extent that it prejudiced either party, would likely prejudice the state more, as the party who has the burden of proving the defendant guilty beyond a reasonable doubt, and as the party who was calling King as an important witness in the case. So to the extent that King's absence somehow would weigh on the jury's mind, I would argue that it would actually be to the defendant's benefit that the state is not able to have a witness like King available. And as Your Honor pointed out, between first trial and second trial, that would give King and any other witness an opportunity to prepare and probably smooth out any issues that might have occurred during their testimony in the first trial. I think it stands to logic that if you're the prosecution and you've seen a witness on the stand and you've recognized perhaps where some of his deficiencies might have been, then you'd be able to learn from that first trial and help him overcome maybe some of his issues that he might have had. So I think it's purely speculative to say that the defendant was prejudiced. And I do appreciate counsel's argument that yes, ideally you would always like for the jury to be able to see a witness in person and make those credibility assessments. But as Your Honor pointed out, it is not all that uncommon for a witness to be unavailable, whether that's because of death or some other issue. And it's well settled that as long as there's been this prior opportunity to cross-examine, that reading the transcript of the first trial is sufficient. And that's especially so here, even more so than a preliminary hearing, where at a prelim, even though the defense might have some incentive to cross-examine a state's witness, it's not quite the same level that it is at an actual trial. So here they got the full opportunity to cross-examine him, to explore those credibility issues, and to the extent that there were credibility issues that popped up in his testimony, again, I would argue that benefits the defendant here because they're able to point to those at the retrial and say, look at how inconsistent this testimony was, or look at these gaps in King's memory or his testimony here. And because he wasn't available, the state wouldn't even be able to attempt to rehabilitate him. So again, I would argue that there's no showing of actual prejudice. And he doesn't address, he's never claimed that there were any oppressive aspects of his incarceration. So he really seems to just be focusing primarily on King's absence. And I see that I'm out of time. If the court would permit just a couple of moments to address this issue with respect to King in general.
That's fine.
Thank you, Your Honor.
A couple of minutes.
Sure. Both in the prosecutorial error and in the third issue, they're pointing to the fact that the defense wanted to be able to point to King as the real perpetrator. But I cited in the brief that there's nothing tying King to these crimes. First of all, we have the DNA evidence, which linked the defendant and excluded King. We have all sorts of indication in the record with respect to how King learned about this. It wasn't something where he just went into the police after the fact. He had warned told the parole officer months before the killing. He had warned the victim. So that the record is full of indication of how he learned about this. And of course, he worked with the victim. And so it's natural that within a day of the murder, he found out about it. And then just briefly, as far as the comments that the prosecutor made about Clifford not identifying the defendant, as Your Honor pointed out, the defense set this ball in motion by specifically telling the jury in opening statement what they said the evidence was going to show. Well, that's not what ended up coming into evidence. That was a gamble that the defense attorney took. They didn't present any evidence of it, nor did the state. And so the state, when you look at those comments, I guess I dispute the characterization that the defense has for those. I think that when you read what the prosecutor is saying in context and in their totality, he's simply telling the jury, look, you can't assume one way or the other, because all we know is that he was not asked the question at trial. So you can't speculate. All you can do is confine your consideration to the evidence that you've actually heard, and you can't speculate. And I don't think that the prosecutor was implying one way or the other what he would have said if he was asked. The prosecutor was simply saying he wasn't asked the question, there was no testimony about it, so you can't consider it, period, one way or the other. So I don't think that those comments were in any way improper. In fact, I think that they're entirely consistent with what the instructions tell the jury, which is you're to confine your verdict and your decisions to the evidence and the law. And because there was no evidence about what Clifford would or would not have said if he was asked, you can't consider that.
Are there any questions?
I appreciate the extra time. And if there are no further questions, our position is that there was no error, let alone reversible error, and we respectfully ask that the defendant's conviction be affirmed.
Thank you.
Thank you.
Okay, you reserve 3 minutes, but in fairness to you, I will give you some extra time to do it. So,
Thank you, Your Honor.
proceed.
Thank you. The state is entitled to make decisions about how it wants to proceed with this case, but that shouldn't come at Robert's constitutional right, at the expense of Robert's constitutional right to a speedy trial. The state gave this DNA evidence to the defense counsel 10 days before the mistrial setting, for the first mistrial setting. Defense counsel should not have been in that position. Robert should not have been in the position had to choose between effective assistance of counsel and the right to a speedy trial. I am asking this court to reverse Robert's convictions due to the trial violation, and I would conclude my argument. Thank you.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. Just a bit of explanation about what that sentence means. That is that this afternoon, the court will discuss the cases we have heard today. We'll make at least preliminary discussions, and those may continue on further days. Once the court has made preliminary decisions about the outcome and the analysis, one of the justices will be assigned to write a draft opinion. Members of the court, that process will continue until we have reached a agreement as to written decision. There may be disagreements, which would result in separate opinions by some of the justices. When the decision is ready for publication and filing, that usually occurs on a Friday morning. There is a press release that accompanies that to let the public know about the decision. I like to note that one of the things that sets our branch of government apart from other branches of government is that written decision-making process that gives a very transparent view into what drove the decision and the reasons for it. Gives everybody an opportunity to read that and understand the decision-making process. Again, counsel, thank you for your arguments. We'll now call case number 123710 in the matter of the parentage of EA, a minor child. Counsel may come forward. Mr. Booth?
Madam Chief Justice and Justices, may it please the court, we're ready to proceed. I'm Joseph Booth, appearing on behalf of DA, the appellant in both cases. I begin my arguments below in the adoption case by pointing out that there are rubrics that you can review the history of a case, and many times it's under an issue of conflict. This is one of these circumstances in which you have to look at what's going on by the way people behave when they're exhibiting their love. It's a different pathway, not necessarily less vicious, but the issue of intention sometimes rings very differently. And in looking at the parade of horribles that represent what happened below, especially in the adoption case. We have the accusations and concerns raised by the Court of Appeals of fraud on the court. We have the fact that it was done surreptitiously. We have the fact that it was done as the petition as a raise to the courthouse. That those are all circumstances that are troubling.
Let me push back on that, Mr. Booth. I mean, I started out kind of reading all this and I got myself animated too. Because that initial pleading states under oath that this boy had been living with the paternal grandmother, when in fact, and that just clearly wasn't true. So that had me animated. But going back and reading the hearing that counsel on the temporary custody orders for the paternal grandmother and her husband, it was very clear that the boy was with the grandfather. So as much as the pleading shouldn't have said what it said, and it was under oath, and I get all that, but really, I don't see how it misled the court, because the court, even though it might have read that, is being told, on the record by counsel, what the real facts are. And so how does that, I don't see that with the same force that I think you've argued it. So where am I wrong?
I would quibble when I read it, and the context in which I read it was we'd finally gotten the record on appeal. That was the first time that we were able to see that as a participant in this process. And as I read along, the first thing I was concerned about was, am I sitting here saying that a member of the bar and the opposing party are lying to the court and misleading the court? And I take those kinds of things seriously. I frequently will say, I'll go so far as to say they're wrong, but lying has to represent some level of intent, knowing that simply isn't so, and trying to make it so. When Mr. Hazlitt presented his arguments to the court, they were in a very muddled fashion. If the court had a bias, if you want to call it that, of having read the original petition and the motion for not having this home study, and then listened, the excuses around wanting the temporary orders had a lot to do with the idea that he was an attorney and could come in and see the file. That was a concern. That he's Nicaraguan,
Right.
so he might
Nicaragua and all that.
Yeah, so he might abscond with the child, that he might not give the child back. So all of those can be seen as a subset of or portion of the fact that it laid out a story that grandma raised the child, grandpa is the interloper, and he's trying to use his muscle, so to speak, to start controlling the life of the child over grandma's objections and fear that he may abscond with the child and go to Nicaragua. That's how I read it. And I, in fact, had an opposite visceral experience than what you did, in the sense that I began with the petition and the motion with suspicion, going, this can't be right. How's it going to be rectified? And then, as I wrote in my brief, they sort of doubled down in that hearing to get what they wanted out of that, using the inflammatory language, using what I would call racially motivated kind of conversation there. There was no even reasonable assumption that there was going to be a kidnapping. My client's an attorney here in town, businessman, well settled, with property and family. It would have been an immense sacrifice and lunacy for him to attempt to do something like that. So it was an outrageous comment in the first place.
We're getting close. I want to bore down a little bit into the
Please do.
merits. Because this is what's been bugging me. Let's assume he has standing. Let's assume there's a right to appeal. Now we're in the merits. His ticket to participate in the adoption proceeding is because of his accusation about the parentage.
Right.
Right? But the statute on parentage says it's a rebuttable presumption, and it is rebutted when you have a court order that declares who the parents are. And we have the October 2013 order that said who the parents were. You can't get around that, doesn't seem to me.
It seems that
So I think so. Let's get him into the courtroom. Fine, but he's going to lose, right? Because that order is just a brick wall for him to go any further.
but is it though?
How would it not be?
I get what you're saying, and subsection B of that statute says the presumptions, and then the next line, and then a comma, and it says the court order. But every court below has wrestled with the idea of estoppel and other legal principles that somehow bind him by an order that he didn't participate in. He wasn't.
Plain language of the statute closes the door on his claim, doesn't it?
I think if you read them both in parallel, how do you bind somebody by a court order that they had no participation in?
Let me take it.
The October 2013 order, parents were declared. This was long before the grandmothers involved. This was in October 2013. So I don't understand what you're arguing.
Well, DA was not a participant in that. And how is he bound by an order that he didn't have any opportunity to participate in?
Let me take a right turn here. Justice Biles asked, isn't this his ticket to participate? His ticket to participate in the adoption hearing is parentage. But let me ask you this. If we look at the Adoption and Relinquishment Act, specifically the definition that everybody's talking about, 59-2112H, which defines party in interest. Under subsection H2, a party in interest is a prospective adoptive parent. Would you consider, I call him Grandpa, Grandpa, would you consider Grandpa a prospective adoptive parent considering the pleadings, the motion to intervene that had been filed?
He did not file a petition to adopt.
Right, but
He
is
had an
that
alternative
required?
request.
That's what I wrote in parentheses. Does a prospective adoptive parent, does that require a petition to have been filed? Because in the, as an adoptive parent, I was always considered a prospective adoptive parent. It was under the SYNC code, which I'll bring up in a minute, but, what is the definition of a prospective adoptive parent? I mean, clearly he considered himself to be an adoptive parent. So would he not have qualified as a party in interest at the time he filed his motion to intervene as a prospective adoptive parent?
I am not sure, but because I haven't looked at it in so long, but I thought one of the alternatives was to grant an adoption in his request. He wrote that petition before I was involved in the motion to intervene and in the motion. But your point.
Well, does he have to even request it?
Yeah.
I mean, does the court, I want to intervene, okay? And the reason I want to intervene is I've been considered an adoptive father. I mean, that's one other argument. He also has the parentage argument, okay, under a different statutory scheme, but this is what has been troubling me. And then if he is a prospective adoptive parent and a party in interest, doesn't that trigger his right to the records? And doesn't that trigger the district court having to hear from him at the adoption hearing?
The answers would be in the affirmative.
Thank
Yes.
you.
Going back to Justice Biles's point, where do we go from here? That would have been one of the potential avenues. I'm reading down the adoption opinion from the Court of Appeals, and one of the things that the Court of Appeals offers is two avenues in which the court would have set aside the petition. The court could just not grant the petition, which puts us in a position of where whatever avenue is left, including the potential of competing adoption petitions, or set it aside under the idea of fraud on the court. And if it was set aside under the idea of fraud on the court, that makes it even more difficult to have a prognosis that grandma would prevail over grandpa under these facts. Grandpa's most difficult fact is from age 7 to 12 now, the roles have been reversed and the child's been raised at grandma's house, but got there inappropriately. Does that help?
Before you are out of time and sit down, could you quickly address or articulate your understanding or your best argument for why the Court of Appeals in the parentage action misapplied our precedent? I think that's one of your primary arguments, correct?
Yeah. First of all, I don't think MF should have been applied. It was a new rule of law that arose after this action had effectively reached conclusion. He had been found he didn't have standing, and we were litigating the parentage action. MF starts off on a radically different path on notorious recognition than has ever been seen in Kansas beforehand. This idea of time barred because of at the birth. And that's why I think it was misapplied in the first place. I also argue that I think if you take MF and apply it under all circumstances of notorious recognition, then it doesn't, I think it's wrongly decided.
Okay, so your argument is MF is wrong. Either it shouldn't have been applied or it's just wrong.
That's fair.
So what, from your perspective, is your best case in our case law or the parentage action? Is it Frazier?
Yes. Frazier and Ross.
Let me pursue the discussion about MF for a little bit. There is probably one regrettable sentence in MF, but isn't the overall discussion of MF trying to find a balance of how we apply Troxel and protect the parent who has a voice and make sure that they have a right to speak as to who the other parent is or should be? And the idea was that in that situation where you had that, the facts of that case, that should happen at the time of birth, where there would be a notorious acceptance of parentage at that point in time.
I think the most
Troxel changes. I mean, to apply Troxel is very fact dependent, isn't it? Depending upon when the various relationships form or disintegrate. Would you agree with that? And does that mean that if we apply Troxel and the intent of Troxel to protect the right of the known parent, how do we apply that overlay of Troxel with notorious recognition, which is what MF was trying to do, to this case?
First of all, that's the most laudable part of MF, is the portion where there has to be some level of acquiescence or agreement on the part of the biological parent. In this case, in the MF scenario, we'll call mom 1 biological parent, mom 2 presumptive parent. And there has to be an interplay there. And the conversation in MF about you can't just randomly start notoriously recognizing yourself as somebody else's child over their objection or without their knowledge, and then somehow establish parentage in that way. That I agree with. And of course, we have that in buckets here in this case, in the sense that both biological parents, one, aggressively established this relationship at 7 months old and then reaffirmed it a number of times over the 7 years until all of a sudden there's this consent for the adoption and in a change of behavior. And the mother was never involved. There's nothing in the record to say that there was at any point post-birth that she acted as a parent. And obviously, EA was not hidden. So mom could have at any juncture. So they never parented and never wanted to parent. And so Troxel then drops way down because Troxel has to do with that parental preference doctrine. And here we have parents who had no interest in exercising their preference, and they're not parties to this action in the sense that, as the Court of Appeals opinion noted, this is a contest between grandparents, not parents. So the parental preference doctrine has very little role in this.
In your view, is I'll call it an agreement between your client and biological parents I think it was at about 7 months old. Is that correct?
That was the formal
There was some kind of.
transition point, yes.
And there was an agreement of some kind.
Yes.
That's what I want to ask you about. In your mind, is that agreement identical to, almost identical to, or significantly different from the agreement that was at issue in the Frazier versus Gottschalk case?
Beyond timing, they're strikingly similar. I can't.
If I could follow up on that quickly, and feel free to correct me if I'm wrong, and my colleagues might want to correct me also. My recollection of the agreement in Frazier is that the court essentially treated it as a contractual agreement to share a parental privilege. Would you characterize the agreement in this case the same way?
Yes.
Okay.
I'm conscious I'm over time, so.
Other questions? Okay, thank you. Ms. Phelps Davis?
May it please the court, Rebecca Phelps Davis, hearing on behalf of DP and SP appellees in these matters. I just want to, first of all, address whether there was lying in the petition on the part of paternal grandmother. If you look at paragraph 6 of the petition, she said the places where the child has lived within the past 5 years are with the paternal grandmother, who is the petitioner in this case, periodically with the biological parents, and at times with the paternal grandfather. She did not assert in the petition that she was the only one that had been raising and caring for EA.
Isn't it, but is the previous paragraph say the child resides with grandma?
Because at the time that she was filing the petition,
No, she filed the petition 7 days before she went and took the child for a visit.
it was addressing that right when she was filing the petition, he was with her.
No, the record shows that on whatever 24th, she filed the petition. Let me get out my chronology. On May 24th, she files the petition, paragraph, which I want to ask you about that in a minute. Petition for adoption and termination of parental rights. And then paragraph 5 says child resides with grandma. And paragraph 6 says child has lived for the past 5 years with grandma, periodically with father and mother, and at times with grandpa. And then on May 31st, grandma requests a visit, picks up the boy, and never returns the boy to grandpa. So it was actually 7 days before, right?
Yes, that the petition was filed. Yes.
And your argument is that that was truth?
Yes,
Why?
because what she was trying to convey in that paragraph is that he has lived with her. And it's the same thing she was trying to convey in paragraph 6, that he has lived with her over the past 5 years. And he has lived with paternal grandfather over the past 5 years.
At times.
Correct, because
So-
that is what the true relationship was.
So this is what she meant, but when you read it, would you say it sounds different from the plain language?
I'm sorry, Your Honor, I don't understand.
Okay, I'll move on. The petition was like one of these double petitions, okay? So it was a petition, was titled Petition for Adoption and Termination of Parental Rights. I could be wrong, but and there was a lot of, the record is quite big in this case, but I didn't see any statute cited in the petition. So my question is, or in the order, in any of the orders. So my question is, since it does include a petition for termination of parental rights, which of course is governed by a different code, what was the statutory basis for this double petition?
Well, under the Kansas Adoption and Relinquishment Act, the petitions are required to address that you're asking to adopt the child and also asking at the same time that the rights of the biological parents be terminated.
So is there a statute under the Adoption and Relinquishment Act that allows the court to terminate, or is the termination governed by the sync code?
No, it's within the Kansas Adoption and Relinquishment Act.
Can you
It
give me
gives
the
court-
statute?
I do not have that in front of me, Your Honor, but
I know it allows you to combine them,
yes. And it
but when a
allows you to-
termination happens, can that be done under the Adoption and Relinquishment Act?
Yes, it can, Your Honor, and I apologize, I don't have that cite.
Okay.
I do
And what are the grounds for termination in that situation
that-
under the statutory basis in an adoption?
Right. The grounds are that you have to show that the parent, the biological parent has abandoned the child insofar as that there has been no contact of any nature, either financially or physically and emotionally, with the child for the 2 years preceding the filing of the adoption petition.
Barring
And-
consent, or consent could be another avenue.
Correct.
Yep,
And
okay.
so because the net effect of the adoption is going to terminate the parental rights, whether you have a consent from the biological parents or not, you still address in the petition, calling it a petition to adopt and terminate the parental rights. Many times, though, under the Kansas Adoption and Relinquishment Act, you have a situation where there isn't a consent and you do have to prove that there's been an abandonment by the parent for the past 2 years, both financially and emotionally and physically. Been no contact. And that's the reason that the petitions are titled the way that they are.
Let me ask you what I asked opposing counsel. So, under 59-2112H2, a party in interest is defined as a prospective adoptive parent. Why wasn't Grandpa a prospective adoptive parent under this?
Well, first of all, in his motion to intervene, he was not addressing that that's what he wanted to be. He was addressing that he has been the one to care for the child and doing this and adopting this child out from under him.
Did he attach to the motion to intervene the consent signed by the biological father? So, I mean, he used the word adopt a lot in the motion to intervene. Would you agree? I mean, he said,
Right.
we celebrated as adoption day on the day that bio dad signed. He considers his bio dad his brother.
He said a lot of things in that motion, Your Honor.
Right, so would
And he also
that,
said that they're unfit parents,
well, so
which
did
is a
you.
legal term.
Well, because you just explained that
Right.
that's one of the
But
things
it
for
ha-
termination of parental rights.
Correct, but you have to have that finding before you can then assert that they're unfit parents. There's got to be a finding by a child in need of care court or in a Kansas Adoption and Relinquishment Act petition.
Okay, well, that's kind of getting me off course here.
Okay.
Why wasn't he to be considered a prospective adoptive parent?
Because he wasn't asking the court through the motion to intervene to be the adoptive parent. He was asking instead for the court to not let paternal grandmother be the adoptive parent because of the history and because of the way it was done.
So you're
And
saying he
because-
wasn't saying because I want to adopt?
Correct, correct.
So
And he
this-
also had 2 previous occasions where he had the documentation that he could have gone forward and he could have filed his own petition for adoption. He could have filed a child
Well,
need
I'm
a
just
care
talking
case.
about the plain language of the statute. So, you get a pleading that says, here's the deal. We're filing a petition to adopt and terminate parental rights. And in there you say, the child resides with me and has lived with me the past 5 years, periodically and at times with other people. And so then you have grandpa files a motion to intervene and you're looking at, does he get to be heard? Does he get to be heard?
Right.
And 59-21128 says he gets to be heard if he's a party in interest. And a party in interest is defined as a prospective adoptive parent. Would he be considered a prospective adoptive resource parent?
I don't believe so, Your Honor.
And why not?
Because I think because, first of all, he didn't take advantage of that when he had the opportunity. He was not asking to be a prospective adoptive parent.
Okay, let's look
Parent.
at it from a due process point of view. Should the court have considered him a prospective adoptive parent for due process
I
reasons?
think it's his job as the person making the request to make that request of the court before the court can assume that he wants to be a prospective adoptive parent.
So it's your position that, based on all the pleadings that were filed in that period, in that 17-day period or whatever it was between the petition and granting the adoption, all of the pleadings that were filed there, the court would never have considered him to be a prospective adoptive parent
Well,
because he didn't raise it.
that's what I'm saying, Your Honor, and that's clearly the way the court looked at it.
Okay, let's just pretend for a minute that he was considered that. Would you agree that, based on that, the district court would have erred in denying the motion to intervene?
If you use that analysis and that because he files a motion to intervene, that he should be considered a prospective adoptive parent, even though he hasn't asked for that
Right, I'm
and
just
hasn't raised it.
right. And then in turn, would you agree that he would have gotten all the records, and he would have, and the court would have had to consider all of his testimony and evidence presented?
Well,
At the adoption hearing.
using that line of reasoning,
Okay,
Your
thank
Honor,
you.
I'm saying,
The focus this morning has been on grandmother, grandfather, no real mention of EA. And I appreciate that's what we're here about is their legal interest in continuing their parental relationship. Both sides have that. But what about EA? I just keep going back to that day where the custody changed. He leaves for a grandparent visitation, never to return to the only home he ever knew. How can that happen? Explain to me how that happened. And, I read the Court of Appeals decision on the adoption case. The
Yes.
facts read like a probable cause affidavit for a kidnapping, not on DA's part, but on grandmother's part. Help me here with all
Okay.
this.
thank you, Justice. I think if you go back to the petition and what was being asserted by paternal grandmother and her husband when they requested to adopt EA, she was trying to make it clear that she has had a relationship with EA just as much as the paternal grandfather has. This was certainly not a situation where EA did not know his paternal grandmother and her husband. He had just as much time with paternal grandmother and her husband as he had with paternal grandfather and his significant other and their family. It was not they weren't strangers to him. I think that if you look
Did
at.
anybody even mention that to EA? Hey, after this visitation, you're not going to see grandfather anymore.
Well, I don't think that
father.
I don't think that discussion was had with EA because it was never intended that it would be so.
Well,
That
why
was a
was it so
decision.
secretive? What's the deal here? Why what's the motivation here?
I don't believe that it was secretive, Your Honor. I think that they just made a decision and
Who
in
made a
talking,
decision?
paternal grandmother and her husband made a decision in talking with the biological parents and the situation that was at hand at the time that they wanted them to adopt EA. And it was never intended that he would no longer have any contact with paternal grandfather. Why, if you go with the scenario that paternal grandfather has asserted over and over again in these matters, and that is that there was no contact with anybody but paternal grandfather and his family, why, when there was a request, which paternal grandfather has said that there was a request all of a sudden by paternal grandmother and her husband to be able to see the child, why would he let them? And why would he let them for an extended period of time? If that was my child, I would not let a stranger, which is what paternal grandfather is saying,
Right, and-
all of a sudden have days with my child.
And all of this, in my mind, just should have been presented initially at either the parentage action or the adoption action, and none of this got presented. And that's troubling.
Well, but if I leave you with nothing else, I would like you to understand that this scenario that has been presented is not the correct scenario. There was just as much a relationship with paternal grandmother as there was with
Yeah,
paternal.
and again, all of this should have been done at the outset.
Can I move you quickly to the parentage action and ask you a series of follow-ups? You probably heard my exchange with your opposing counsel. He argues that our Frazier case, if applied here, gives him an avenue of relief. I just wanted to get your response to that. Do you think Frazier, if we applied it, would give grandfather an avenue of relief here?
I don't think so,
Why
Your
not?
Honor. I don't think that the agreement in this case can be compared with the agreement in Frazier
What's the
case.
difference?
Well, I don't believe that the biological father was, he was influenced by the fact that his father was asking him to do that, and the physical condition and mental condition that he was in at the
So
time.
you think this case, the parentage case, turns on biological father's capacity to enter into a contract?
I think that
Was
that's,
there ever any factual inquiry in the lower courts into that question?
there was not, Your Honor.
Wouldn't there have to be under that line of reasoning?
Well, I think that the reason that there wasn't is because that sort of went to the side and it was more focused on the fraud or the alleged fraud and the relationship that paternal grandfather allegedly had with EA and that nobody
If
else
that's your
had.
position, wouldn't you have to concede that at a minimum, something needs to go back for some factual inquiry? I mean, if that's really your position, that
No,
grandmother prevails because biological son did not have the mental capacity, or did not have the legal capacity, I should say, to enter into a contract.
yeah. My position is that he had that agreement. And if he wanted to do something with that agreement, as well as the consent, he could have taken the steps. He did not.
What steps are you talking
He
about?
could have filed for adoption once he had the consent. He could have filed for adoption once he had the other
How is that
agreement.
different from Frazier? I mean, Frazier, they didn't do anything with the agreement either until there was a dispute. How is that any different from what
Well,
happened here?
Then the difference between this case and that case is the conditions under which father signed the consent.
And can you explain what those were that make it different from Frazier?
Well, I think the record has.
Or you're back to lack of legal capacity?
Yeah, the record has made it, it's been put in the record that the reason that the parents were not able to care for the children is because of their drug use.
Can you articulate any other factual difference between the agreement in this case and the agreement in Frazier, aside from the purported lack of legal capacity?
No, Your Honor. I
Okay,
cannot.
thank you.
I think I'm out of time. Is there any other questions?
Thank you.
Thank you.
Thank you.
Mr. Booth, explain to me how your client can be the adoptive father when there's no consent for adoption from the mother?
I believe if an action for an adoption were to proceed either at the point that we started this action.
Take the written consent.
Wait,
That had been timely done. How do you get to this status of adopt father? I realize you can claim anything in a pleading, but how do you get there?
both parents had failed to function as a parent for well over 2 years.
What's
And
that got to do with adoption?
in the,
Adoption is a legal process,
right,
and you have to follow the statutes in order to make it happen.
and 2136H, when you want to terminate a parental relationship and you don't have a consent, one of the factors is, did the parent act as a parent in the 2 years preceding the petition for adoption? And in both cases, neither parent acted as a parent.
But there are findings by a court to convey that status. The idea of being an adoptive parent is a legal status conferred by a court. It's not conferred by yourself, right?
And you're referring to an adoptive position.
I'm just talking about being an adoptive parent, and you don't have it here. You don't have an adoption.
There isn't a status of an adopted parent, but the seeking to adopt and the intent, the forward intention that Justice Standridge was referring to is present. In other words, when my client passed me a note, he said he did file an adoption petition. I was looking through the record. I can't find it. But even then, the alternative pleadings were for him to be considered a parent, a seeking to be a parent.
I understand the
under any
parent
evidence.
stuff. I'm trying to focus on the status of this claimed status of being an adoptive father. And to have an adoption, you got to go to court and get a court order. And you don't have a court order here.
I don't think in the record he's claiming a status of having adopted EA.
Well, this is the point Justice Standridge was making in the very first pleading. I've got it in front of me.
Okay.
The very first thing he files in Shawnee County Court to set aside the temporary custody order says he is the adoptive father
Okay.
of EJE. If you want to talk about deceptions on the court, I don't know what that animal is, an adoptive father, if you don't have a court order. That's my problem here.
Well, let me clarify what I meant when I was talking about it. It's a prospective adoptive parent for purposes of intervening. My point was that because he put in there about the adoption, that the court should have considered him a prospective adoptive resource, because doing that makes him a party in interest. Not that he was the adoptive parent, but the fact that he's referencing that jumped out as a judge and says, oh, we have two prospective adoptive parents here. One who has filed a petition, and then the other one who thinks he is an adoptive parent or wants to adopt, that would qualify him as a party in interest to intervene. So I'll just clarify that.
And I'm still trying to focus on the representation to the court here, which says he is the adoptive father of EJE. That's what he said, the first line in the first pleading that he files in this adoption case. And that isn't a thing without a court order. He might want to do a whole lot of things, and that might get him into the courthouse. I don't have a problem with that. I'm just saying this isn't a thing that gets recognized until you go through the full court process, right?
Right. Okay. There's no common law adoption.
Okay.
Counsel, can I try to get my head around the lay of the land of Kansas law as it relates to this case really quickly? And so I just want to run through some things, and you tell me if you think I'm wrong about anything. Currently in Kansas, we have biological parents, we have adoptive parents, and we have this creature called de facto parents. Or is there any other category of parents?
we have the legal fiction list.
Well, that's what I would call de facto parents.
Okay.
And we also have presumptions of paternity, maybe presumptions of maternity. We have best interests of the child. We have adoption proceedings. And we also have this case law, this creature of case law where a parental privilege can be shared by contract. Would you agree with those sort of pathways to parentage in Kansas law?
Yes.
So I guess my question is, and in this case, we have at least 5 possible parents. We have 2 biological parents, grandfather, grandmother, grandmother's spouse. Are there any other persons involved?
No.
So given all that, my question is there anything in Kansas law which prevents a child from having more than 2 parents?
No.
Okay. My follow-up was going to be to ask you to point out where in Kansas law, but you sidestepped that by just saying no. Thank you.
It comes down to what the case law is wrestling with, in my mind, is the difference between parent as a noun and parent as a verb. And Justice Rosen's question is exactly the point. I was building up to how did that little boy feel the day that he went to visit grandma and found out he wasn't ever going to return. And in my brief, I asked questions along the lines of what in the world was this kid told? And did he struggle with no longer being worthy of his whole family? It was a family unit. It wasn't just DA. And then you wind up burn the clock for 7 years, and you wind up with the child's perspective. And are we going to recognize and are we going to make the child's perspective and life experience in these unusual, exceptional circumstances that a child grows up under the firm belief, this is mommy, this is daddy, these are my sisters. And when my father comes around and visits, I say, hello, brother. That was his world all the way well into 7 years old. That's the map. That's the attachment bond. And that's what gets torn and real damage, if you read the amicus briefs, is wreaked upon this child when you do that sort of thing. And for the court not to have the opportunity to have wrestled with that goes back to the question of why did grandma file what she did in such a convoluted fashion, leading the court to believe that she had a parent-like relationship when she didn't, relying on her role as an employee of the court system as part of the things that made her laudable to adopt, and that there didn't need to be a home study, et cetera. She laid those out because of the insecurities that are found in the fact that this child thought grandma was grandma and that grandpa was dad. And that was his world.
Is there anything in the record that shows whether or not grandpa has had any contact with the child in the last 7 years? I mean,
I'm sorry?
well, I would ask, has EA had any contact with grandpa in the last 7 years? But if it's not in the record, I don't want to know. If that fact is not in the
Yes, well, if you go through the undisputed facts in the summary judgment process, he was the primary care provider and in a parent-like role
No, I
until
understand.
7 years old, and now he's 12.
Right, but has he seen the child in the last 5 years?
No, other than incidentally distances. There's nothing in the record about,
Oh, okay.
to be very precise in what you asked, there's nothing in the record stops about the relationships with the day that the grandma picked up EA.
Okay.
Do we have we consolidated everything in this appeal that will fully and finally determine the rights of these parties? Is there any other action that is floating out there that could affect, in particular, EA, but also the rights of these parties?
None that I'm aware of at all. And it goes to the point of when we process these things, it comes before the court, as Justice Rosen said in TMMH, we treat them as separate actions and collateral attacks on an adoption, et cetera. But it's really one action. It's really a combination of things talking about the same or subject, and they need to be consolidated. And I thought that our courts had given adequate guidance to do that. But we still wound up in separate tracks in this case.
Well, the habeas corpus case died at the district court level, right?
Okay.
So I'm getting back to Justice Wall's question. That's dead, and there's nothing else out there.
And there was a removal action.
Well, that was,
Which is gone. There's no other action that my client's a party to or that we're in any way aware of.
Other questions? Thank you. Thank you to both counsel. I will mention, I failed to, as Justice Wilson left, to mention that for those who didn't receive the formal notice from the court, that Justice Wilson did recuse from this case, which means she will not be participating in the decision making. That the court is now in recess until 10:45.